like few minutes before the court. So that's number two. And last point to Ms. Longwitz, in her 34 years, she has never attended a case. This is the kind of information, misleading information, that I was referring to that she presented to the court. Ms. Longwitz states this statement, yet she does not state that it was her who caused all these. She is chastising me and asking the court to take a position against me because I'm defending myself against her aggression. I did not file for anything other than filing for the custody of my child. Every time I was filing, I don't know if it's appropriate, it's not appropriate, I'm not going to say it, but just tell the court the gist of it. She kills me with my own weapons, and then she cleans her hands with my own shirts, and then she asked the court to make me pay for the dry cleaning of my shirt.
I didn't say it would be easy, Neo.
Mr. Lamnisos, are you here?
I am, Your Honor.
All right. So if I recall last time, Mr. Lamnisos, you told me that you struggle with ADHD. Is that correct?
Correct, among many other
All right. So
health issues.
All right. So here's what I'm going to ask you to do today. I'm going to call your case in just a minute. I want you to come up with your 3 top arguments, and you're going to tell them to me, and then we're going to try to organize your arguments around those 3 top things. Now, you've got to remember that you've got 30 minutes. Why? Because Ms. Longwitz needs time to respond. So you cannot just talk at me nonstop for an hour. It's not going to happen today. All right. So let's call your case then. Okay, we're here in D-1-FM-23-002729. Michael Lamnisos versus Dina Zanan. We're here on a motion to modify / correct order, motion to reconsider that was filed by Mr. Michael Lamnisos. Mr. Lamnisos let the court know at the last hearing that he has a disability for which he was requiring some accommodation. But last time we let him have the floor and talk as much as he wanted, I will say his thought process became highly disorganized. For that reason, today we are going to ask him to give us his top 3 arguments and try to keep his court arguments structured around those top 3. So, Mr. Lamnisos, what are your top 3 issues that you want to talk to us about today?
As far as issues are concerned, there's mainly one issue.
What's that?
Which is the modification of the order after it was rendered by Your Honor orally in the courtroom, and after a signed draft was made by both parties.
Okay, so you stop there. You stop there. See, that's all I need you to. We're high level right now. Ms. Longwitz hasn't even announced yet, so you're going to have to kind of get it together a little bit. What's your second big issue you want to talk to me about?
It depends if Your Honor gonna take in consideration in your decision today the answer that the counsel filed to my motion, then I will have to respond to that.
Okay, that's your second issue. What's your third issue?
Third issue is
No, there isn't. There's 2. Okay, stop. Now, I'm going to call, let's see, we've already called it. Ms. Longwitz, would you please make your announcement?
Yes, Gina Longwitz Domestic Violence Clinic, University of Texas School of Law, here for Dima Alzaknon.
Okay. Thank you, Ms. Lundvitz. Do you have one of your students with you today?
I don't. They've all graduated.
All right. Well, it's always a joy to have your students here, and we look forward to bringing in more next year so that they can have an opportunity to see court proceedings and get their sea legs in the court, so to speak. All right. With that, Mr. Lemnisos, I started the clock. You've got 30 minutes. First issue is modification of the order. All right. Please try to organize your thoughts, and you may proceed.
Thank you, Your Honor. My thoughts are pretty much everything that is mentioned in my motion. So I'm just gonna, for the sake of complying with your honor instructions, I'm gonna try to just reiterate that. Just a quick point here is I am not in a position to correct, object, or even mention the disadvantage that people in my position in general are at in this court. The main obstacle in my way basically is the fact that the system, the central docket system, imposes that every time I need to present something to the court, I mean, let alone my health issues or disabilities or what have you. The court and the law hold me as a pro se for the same standards as it holds counsel, a certified attorney. Yet at the same time, it does not grant me neither the privileges nor the stature or whatever it is that your honor would like to call. So to begin with, I'm at a big disadvantage. So the least I would ask for is that I would be treated fairly and justly and without bias. The bias against people.
May I just say this, Mr. Lemnisos?
Yes.
It is my full intention, as it always has been with you and with all litigants, to treat you justly and fairly. Yes, I will say pro ses are held to the same standard as counsel. However, in this court, we do attempt to give you some assistance, as I have today, by telling you at the start of this hearing how to organize your argument, which you ignored. So you have had that opportunity, but nonetheless, I reassure you that in all things, I will treat you justly and fairly. And with that, you may proceed into your argument.
I can't ask for anything more, Your Honor. I would like to ask first, before I proceed, whether Your Honor is going to consider the answer. So do I need to address that also or not?
You may address whatever you think is important.
Okay, so in this case, I will start with the order itself, the main issue here. Since the start of this case, which is extremely complicated and convoluted, it involves two other cases. I had received, I can very clearly, assure that on the record, that I was not treated fairly, and I did not receive any fair treatment or opportunity to defend myself or to present my case to the court. Now, with all the events that happened, the opposing counsel, since she started her involvement in my situation back in May last year, held nothing. Your Honor got practically mad at me last time for even Even though I didn't call her a liar, I did call what she presents to the court as lies.
Okay, here's the
But that
situation.
is,
The reason why I get angry with that is because you are held to some standard, and ad hominem attacks against opposing counsel, they're inappropriate. So when you're using word like lies and liar, you need to be very cautious on that. All right. That's why I don't think I got mad at you, but I'm just telling you that's inappropriate as it is today. So please proceed, but keep in mind that those types of attacks are not appropriate in the court. All right, you may proceed.
I understand, however, my major problem here is just like in this answer that she filed today, since she started her involvement in my case, she has presented her entire conduct is a subject for a different venue and a different issue. However, the point that I was making is that even though Your Honor just mentioned now that we are held to the same standards, I don't see that we are held to the same standard if the opposing counsel, because of her stature or her relationship with
No, it's not her statute or her relationship. See, she's opposing counsel and she's an officer of the court. So we treat her with respect as an individual. We don't attack her personally. It's not that because of her stature or her relationship. You need to get that straight. Now let's be clear here. You've used 7 minutes and we still haven't gotten into the body of your motion. You've told me how you're held at a disadvantage, you're treated unfairly, and you've attempted to attack Ms. Lundquist. That's all you've done. And I don't know what you're here for so far. So please focus as I asked you to at the beginning, and let's hear what you're here on because you are running out of time.
Okay. I try to help myself by setting a timer in front of me. Okay, so back to the main issue, which is the order. I needed that order. The court issued, and that's why I brought these points, several orders, several, and I'm not talking one or two, that are plain wrong and does not comply with the law, does not is not correct, at least, and at the minimum, I do have the right to challenge those. Now, we're not talking about trivial orders here and there. We're talking about some serious issues such as the esteemed professor of law uses the law clearly and blatantly to her advantage wherever, just a small example, whenever a certain law applies to her needs.
We're getting off track again. And
we're not,
but we are. You need to tell me what's wrong with the order. We're back on casting aspersions on opposing counsel. What is wrong with the order? That's what we're here on.
The wrong with the order, Your Honor, is I need to challenge all these orders that were issued and challenge the so-called final decree of divorce because this is not a divorce case and shouldn't have been. In order to do that, and because of the severity of the injustice that I have received and the compiling wrong orders over wrong orders by this court, I have the means that I can go to is a writ of mandamus. In order to do that, as explained to Your Honor in the last session, I did not attend the so-called final hearing on the divorce because, and I explained to the judge, I did not, as the esteemed professor claimed to the court, that I just took off or I did not show up. I did show up, but I did not show up and I did not announce ready for a final decree of divorce. I showed up because I was forced by this court and by the improper communication between the counsel into waiting to the very last minute to hear my motion for continuance, even though my motion for continuance has a very, very compelling argument and reasons. Now, I am left to the point where the final decree was issued, even though without my presence. So my next step was to file for finding of fact and conclusion of law. Again, the court did not provide not a single fact or evidence upon which it based its against so-called final decree of divorce, which is the least, I mean, without putting yourself in a at least I can call it savage. There's nothing less than that I can call it. Having said that, with my limited resources, that was mainly my status, mainly aggravated by the actions of the opposing counsel. Of course, officially, it's the action of my ex-wife, but in reality, it's the counsel who is doing all this, starting from filing the frivolous suit, providing misleading information to the court, which I called previously with a poor choice of words, lies. However, that does not change the fact that she presented misleading information and mistruth to the court. Based on that, she received a favorable judgment. Now, the entire process that the opposing counsel did is explained in different motions that was presented to the court. I predicted what's going to happen, and that is the reason why I was fighting this so hard. But you know, I can probably, I'm not a lawyer, and there is no miracle on earth can make me a lawyer within this short time. But even said miracle happened, I still cannot face. I might learn the law, I might learn the research, but I cannot learn how to oppose such conduct of the council. What can I do? That led us, the entire thing, this order that Your Honor signed is the last straw that practically did, I don't know, it's just practically destroyed any hope that I might have to really get some form of justice or fair treatment. There was an order. I argued my motion. I explained to the court in my motion as well as in my oral argument. As hard as it was, I tried. I need those transcripts to challenge these orders through a writ of mandamus rather than an ordinary appeal. An ordinary appeal is okay when I'm challenging only the so-called final decree of divorce. I am challenging the entire process from A to Z with each and every single order that was issued in this court. And subsequently, a wrong order is passed, and then more order accumulated on top of it, and we reached to the point. And there's no need. I mean, if Your Honor would grace me with 5 or 10 minutes, I don't know if you did or did not read the counsel's response. That shows the true and real conduct. The counsel, more than once, in the very first time that I requested this, which was back in
Okay,
you've
used half of your time. Just be aware of that.
I am
Already 15 minutes.
I am
So
in front,
you need to wrap up. You've got only 15 more.
It's in front of me.
You're done. And we got to switch to Ms. Longvitz.
Okay, it's in front of me. Now the Ms. Langwitz on this particular issue more than once stated to the court that she has no stand or no position whether I do or do not get the fee for the transcript waived. Now, she stated that in the very first time that applied, which was a judge's Connor back last year. In Your Honor's court last time, she reiterated the same, both orally and in writing, that she has no position. She does not oppose me getting the transcript. Me getting the transcript is my only means. I did not participate in that court, in that session, because I did not want to acknowledge that this is a divorce case. This is not a divorce case as it was announced on the docket sheet, as it was the final order issued in it. All these I don't know what to call it better than a legal salad that happened, grabbing something from here, something from there, just throwing everything together. And I am given with all my limitation and all my on top of it, my disability and inability to behave and conduct myself as a lawyer in this court, let alone a professor of law. I didn't do anything to get myself in this position. I do need to have my say. I need the court to hear me. I need to.
We're sitting here now
evidence.
listening, Mr. Lemnisos. We are
Yes.
sitting here. You've got my undivided attention.
Yes, ma'am. I'm
Okay,
just.
so it's not that we are not
No,
letting
no.
you have your say. You've
Yes,
got.
Your Honor. Excuse me, Your Honor. This is my other major problem is I'm constantly misunderstood, just like what happened with Your Honor last time when I was trying to say that Judge De La Yata did not have knowledge or did not have anything in his hand to show him that there was a divorce. And you took it, of course, naturally, as I was trying to insult the competence of Judge De La Yata. Then I had to go through hoops in order to explain myself. So I do have this problem. Please take that in consideration. I try as much as I can. I do speak 5 languages, but still English is not my first language. So sometimes it does take me a little bit to, especially under stress, to choose the right words. However, the intention to disrespect or insult anybody in this court or in this system, including Ms. Longwitz, is not present on my side. I came to you with this motion because I need that. And what I was trying to say, it was not directed to this very court, not Your Honor. I wasn't saying, Your Honor, I need you to hear me. I was just saying in general. My case was heard by several judges in several motions, and neither of them, before we got in, Ms. Longwitz, the professor at law, until this moment, more than a year, used me and my family and my son and my agony and my tragedy as a teaching tool for her students, and I still did not mind that. But to get to the point where not even for a second, we're going to finish today. Your Honor is going to go to your home and she is going to go to her home. You're going to get to hug your children and your grandchildren, and she will too. And here comes my third problem with my ADHD. I am unable to behave, control my emotions in the presence of the court, not because I'm a violent person, But because I am in agony, the picture you see under my profile marks the last day I have seen my boy. August 30th, 2023, with no court orders. My boy was taken away from me without court orders, without any, there we comes to the lies again. Nothing. This case is not about was not about my child, the case of the protective order. When I couldn't get my child legally back home after he was kidnapped by his mother, then I had to file the Sapser case. Now, I'm not going to go into the details, but just going to tell you, Your Honor, I have received nothing but aggression, disadvantage, bias, prejudice, and in several occasions it was blatant, flagrant. I mean, there's nothing that can be. I mean, it's not even covered by some legal, text or context, or if you will, just like that. We're gonna deny you your motion because you did not. Just a quick read to each and every motion or response that was filed by Ms. Langwitz will show Your Honor and show the court, and I would like this statement to be on the record. Ms. Langwitz, until this very day, did not argue, did not defend or act at all in any issue or any matter based on the merit, just like the answer that she supplied the court today. You can look at it and see. What does she say? Does she claim that I shouldn't ask for the modification? No. Is she saying that, I shouldn't get the record? No. What she's saying simply, the court shouldn't do this. The court shouldn't do that because the court lost its plenary power. Now, I'm not, I have to use common sense before I use the legal loophole that she jumped through to come up with these concoctions, if you will. Bottom line, I explained myself to Your Honor, and I tried as hard as I did. Of course, I did not succeed. Just to give Your Honor a small idea about what is going on here. What is going on? What's the situation? But no time on earth with, within these restrictions and within my abilities will allow me to do so. There's so much misconduct, so much convoluting circumstances, so much people, so many moving parts, that unless a person who is hopefully a fair judge in this wants to, get to know each and every these little details, they won't be able to treat me fairly or judge fairly. Now I am in a position that I have to go to the higher court. Okay. Now I can, and I did file a notice of appeal already, simply because I have to. Hadn't I filed that, the court...
You have 5 minutes. You have 5 minutes. So just letting you know the
Thank
time.
you. Thank you. So bottom line, I have filed already the notice of appeal. So the issue of whether I do get or not get the transcript for free is not really the main issue. The issue here is by this addition to this Well, I don't know. I really don't. And I can't claim to know whether Your Honor did add this on your own or whether it was proposed to you after the fact, because I sent her according to Your Honor's instructions. Your Honor instructed her, Ms. Longwitz, to draft 3 orders. Order granting me the motion to approve the statement and the motion to waive. And Your Honor even argued with me whether I really need to or not to, if you remember, like appeal all these orders. So it was clear to the court, what do I need from this motion? By the law, I don't need to file a motion with the court to get the transcript fee waived for the ordinary appeal. However, ordinary appeal will restrict me to appealing the final decree of divorce. I need to get a writ of mandamus to correct the injustice that was done before we got to the point of a final decree. There was severe errors and injustice that was done. This case transferred into a divorce case without any legal basis. The court conducted its final hearing and issued its final decree of divorce without, I am confident 100%, but I do need an evidence in my hand to show that the information was presented to the court is false. The process that led to the hearing of the so-called final hearing on a divorce is wrong and it's illegal. And for that, I need that evidence. I did not participate, so I do not have evidence. I requested finding of facts and conclusion of law. The court did not bother with anything. Court simply just signed whatever Ms. Longwitz provided. Just like the court signed whatever Ms. Longwitz put in her so-called proposed final decree or proposed disposition. I filed, after receiving the not so clear, not so present even facts, finding of facts and conclusion of law, I filed for amended and modified and additional. Again, the court did not respond, but the opposing counsel provided, it's not necessary. Now, it's not necessary for me to know why, on what basis did this court find me married when the court states that it found that the proper documents was filed and there is no document to be filed as to marriage. Then, I need to know, I need to show the court something that this information is false. All that pushed me for the need to file for a writ of mandamus. In order for me to do that, I do need the transcripts. And that's why I filed this motion for the very first time. And then I filed it again with Your Honor. Again, at that time, while Ms. Longwitz stated that she doesn't have a position, yet she filed an answer stating that the court shouldn't grant me that because that order is not a final order. Okay, so we were forced to wait for the final order. Same thing happened with Judge Meacham. Judge Meacham issued an order telling me that I cannot file for dismissal of the divorce case. Why? Under what law? I asked for finding of facts and conclusion of law. You can't have that, sorry. This is not a final order. The stage was set by Ms. Longwitz from A to Z. It went meticulously with the court blessing down the road.
All
I
right,
do need
Mr.
that.
Lumley, because
The judge,
you've now run
2
out of
minutes.
time.
Oh,
It's
I
now
have-
Ms. Longvitz's turn. All
I
right,
still,
you,
I still
thank
have
you.
a minute and a half.
No, you're done. All right, we'll get back to you. Ms. Longvitz, what else do you have for us today?
Just a couple things, Judge. My understanding of what was set for today was the motion filed by Mr. Lemnisos on April 29th, asking the court to correct the order that the court signed on April 17th, that he was objecting to the language that the court added, the language that's set out in blue. There are two reasons why the court probably shouldn't rule at all. The first reason is that the court has lost plenary power. Under 329BE of the Texas Rules of Civil Procedure, the court had plenary power until 30 days after it denied the motion for new trial. That happened on April 17th. So on May 17th, the court lost plenary power and so doesn't have power to hear further orders or further motions or have further hearings in this case. The second reason is regardless of whether the court had plenary power or not, the issue is moot. Mr. Lemnisos has filed the notice of appeal. I've received notice of that, I believe on May 23rd. That the Court of Appeals gave him a cause number, and that's what the additional language the court added said, that any court reporter who is asked to prepare a transcript does not need to comply until provided with the cause number for an appeal. And there has been an appeal filed, and there is a cause number. And I'm not going to take much of the court's time on this, but I do want to say that in my 34 years of practicing law, I have never been to more hearings in a case than I have in this case. Hearings set by Mr. Lemnisos over and over again. The court has, many different judges have given him a lot of time because each time he says he hasn't been heard. That's all I have.
That sounds like you do have a cause number now. So we're kind of in a different situation. What's going on with you in this thing?
In this thing, Your Honor, I had to file the notice of appeal because it was the last day. After I filed the motion for a new trial, which Your Honor denied, it's extended the plenary power of the court to 90 days. And that was the date I filed the notice of appeal. It's just a precaution, so I can, I don't default on that date and lose, which is what Ms. Longwitz wishes for me to do. May I respond real quick
Yes.
to what she said?
Briefly.
Briefly, okay. As far as the plenary power, Your Honor, I mean, the main reason here is my issue is why this language was added after the honorable judge.
Because it has to be that way. Mr. Lemnisos, understand
Okay,
how many litigants we have come through here.
I understand.
We have people who will appeal things
I understand.
and not even show up in court. Can you imagine that? But
I
that's what
can,
happens.
and
We
I've
have
seen a lot.
parents. Listen to me. We have parents who will not even come to try to keep a relationship going with their children. They won't even come to court, but they'll appeal it. So we have to have some regulations and guidelines in place.
I understand.
Not personal to you, right? Not personal to you. These are the rules, and that's why the rules exist. So you need to understand that. Now, what else do you have to say to me?
What I was trying to say, Your Honor, is I understood this fact before I even applied. However, I explained to the honorable judge that I needed to, in order to face all these wrongful orders, I needed to go the route, even though it's an action by the appellate court, it's still it's not it still needs the exact same record. I can only get relief by writ of mandamus in order to correct all these orders. So I had to file the notice of appeal. Now, the reason for filing this motion to begin with is for that little ambiguity in the law where it does not mention that writ of mandamus entitle the litigant to get the transcript fee waived. And that's why I mentioned that. And that's why I even mentioned that orally in front of Your Honor and also in writing in my motion. So as far as this motion goes, I had to file the appeal only because it was the last day. And if I did not file, I will lose my chance to appeal. So I filed the notice of appeal as a precaution. However, my intention is still, I do need to attack all these orders, not a single order, which is what available in the ordinary appeal. Now, to the point of Ms. Longwitz, her plenary power, the plenary power does not cover this post-judgment orders. I'm not asking in this motion, I'm not addressing the final judgment, which is the center point of the court plenary power. And I'm not asking, this is a post judgment motion that was filed timely, properly, and it was set. This is another point where the esteemed professor mentioned in that I failed to set it. I did not fail, but for some reason, the court staff, the court administration office, saw it's proper that they do not let me know. And I did specifically tell them that this need to be heard by the Honorable Azullah because it's her order. And they said, okay. And because of the docket system, central docket system, I won't know which honorable judge is going to be set until the very last minute, like few minutes before the court. So that's number two. And last point to Ms. Longwitz, in her 34 years, she has never attended a case. This is the kind of information, misleading information, that I was referring to that she presented to the court. Ms. Longwitz states this statement, yet she does not state that it was her who caused all these. She is chastising me and asking the court to take a position against me because I'm defending myself against her aggression. I did not file for anything other than filing for the custody of my child. Every time I was filing, I don't know if it's appropriate, it's not appropriate, I'm not going to say it, but just tell the court the gist of it. She kills me with my own weapons. And then she cleans her hands with my own shirts. And then she asked the court to make me pay for the dry cleaning of my shirt. That's what she did. And that's all not a false claim or an angry statement. That's facts within the court's hand, within your honor hands. And that's all that I'm asking. I'm asking that the proper procedure or the common sense, this has improper communication all over it between Ms. Longwitz and the court staff. Because the honorable judge yourself did not even mention any, even though I argued this before you, and I did explain why, and your honor did tell me back that all these records and the cost and what have you, all that was mentioned. And I, at the time, explained to your honor that I don't need, for ordinary appeal, I don't need to waste the court time and file a motion and get an order. I needed it because I want to file for a writ of mandamus. I did not want to file an ordinary appeal. So Ms. Longwood states she doesn't have a position orally and in writing. Your Honor, tell her or her student at the time to draft 3 orders, 2 orders denying my motion for a new trial and my motion to stay or motion for default, set aside default judgment, and the motion granted me. She does not do that. She drafts 2 orders that's suitable for her, which are the denial, leaving me with having to draft that order. And I presented per your instructions to her, and she signed it. She signed it, and she reiterated that she does not have a position. Where did this all of a sudden came, this extreme opposition that she did not challenge my status? She did not say, no, he's not indigenous. He's not, he doesn't have money to pay. She did not go the legal route. In the surface, she has no objection. In reality, I get shocked by after she signed the order, the drafted order. I signed it. We presented to the honorable judge. I get this very specific. And this, just to tell you, Honor, that's my last statement, the very exact language that this paragraph contained is the same exact language that Judge Crump's assistants, executive assistants. Oh, no, sorry. Reporter. She took it on herself. She took it on herself to contact the entire reporters that I requested the transcript from and use the exact same language. And that's why I am extremely concerned of improper communication between Ms. Longwitz and the court staff. Not to mention the fact that after Your Honor explained to me and I explained in your Honor presence, what do I need this for?
I just,
All of a sudden,
didn't I just tell you? Stop. Didn't I just tell you the reason why we do that? We do that in all cases because if someone just comes in and says, yeah, maybe I'd like to take an appeal, prepare a transcript, I don't have any money. It takes hours for us to do that, hours for our court reporter to do it. And sometimes people don't even get appellate numbers. That's why the language is in there. So we have to have that language. It's got nothing to do. I don't even know if Ms. Lungwitz would know how to communicate directly with our court reporters. I don't know, but it's got nothing to do with that. It's because, as I told you, people will come up here. Sometimes they won't show up in court even to defend their rights. They won't even be here, but then they appeal the decision of the court. So we need to know that there's some seriousness before we start providing free transcripts. Hours of work go into those. All right. All right. Are you done?
Serious, Your Honor.
Are you done?
Just one final statement. I just want to reiterate that I did not need this for the Court of Appeal. I still needed. I mean, had that been said during the session when Your Honor rendered your order, your oral order, I would have argued that right then and there. And I did argue, even though Your Honor didn't mention any of that stuff. I did argue it. The fact that this addition was after, I mean, this is what I'm concerned about. I just want to know why. Why after the opposing counsel, myself, and Your Honor's oral, I'm not arguing with Your Honor whether should or should not. I'm saying Your Honor heard my argument, issued the order nonetheless. Yet after the fact, after she signed it, after I signed it, we presented it, then it was added. And again, the exact same language that the Judge Crump reporter used it in an email that she took it on herself to distribute among all. Specifically, any reporter does not need to comply unless you receive an appeal. That's what got me into saying this. As far as improper communication with between Miss Longwitz and the court staff and even some of the judges, that's a subject for a totally different
I'm going
venue.
to take real issue with you saying there's been improper communication with Ms. Longwitz. That's, again, I've cautioned you not to step over that line. All right, so here's what we're going to do today.
Yes.
I do think that Ms. Longwitz has made the correct point that there's no new rulings we can make because the court has lost plenary power. Mr. Lamnisos, I will grant you relief and provide findings of fact and conclusions of law on the motion for new trial. Ms. Longwitz, we don't mind taking a crack at those and then distributing them to you all, or you can do the opposite. In other words, the draftsmanship on it. But that's what we can do today. Ms. Longwitz, let me hear from you.
I had not seen the request for findings of fact and conclusions of law, but if are we granting an oral motion? Because we did that for the trial.
Mm-hmm.
And there are findings of fact and conclusions of law for that.
This is the motion for new trial, which I don't know technically that we need them on that. I don't know technically that we do. We probably don't. It's not something we typically, but he did file them on the request on April the 29th regarding for new trial.
And so my response to that was that the court didn't hear any evidence that day. Nobody was sworn in. It was pure argument. And I don't know what facts can be found based on no evidence.
All right.
I mean,
Your Honor, just one question, please, Your Honor, so I can understand, if you would, please.
It's so helpful for me to hear from Ms. Longwitz. Just a moment, Mr. Lamnisos. I feel like you've had a lot of court time. You've been with Judge Crump, you've been with Judge DeLiata, you've been with Judge Meacham, and you've been with me, and there's probably some others. Yes. But sometimes it's just a wall of information that we're trying to climb with you. Right. So would you please, just for a moment, let's let Ms. Longwitz have some response so I can try to figure out the posture of what's going on.
At that hearing on the motion for new trial, there was a lot of argument. Mr. Lamnisos made a significant argument. We made an argument, but there was never any evidence offered. There was never any testimony. He wasn't sworn in as a witness to offer testimony. And on May the 2nd, the court denied his request for findings of fact and conclusions of law for that reason.
Yeah, because there was nothing new at that. And as I said, it's typically not something we do provide. I'm trying to kind of give them something because obviously we've had an awful lot of information come at us. But I hear you. So, what we were looking at was just, it's going to be a reiteration of the underlying judgment. Typically with motion for new trial, we grant them or deny them. That's it. There's no findings of fact, conclusions of law, especially when it's just an oral motion. So that's kind of what we're toying with a little bit, just because it does appear to be going up on appeal. But the only thing that would be mentioned would be a reiteration of the original judgment, because there was evidence as that. As you point out, there was not evidence at the on the motion for new trial.
Your Honor,
just a moment, Mr. Lamnisos. I need a minute here. I'm trying to help you, but I need a moment of just no words from you. Okay. So yeah, the facts would just be on why the judgment was appropriate, I guess, is the main thing. I don't know. We'll have to think about it some. Let me hear from you, Ms. Longwitz.
Well, and I'm trying to find them here, but the court, there are March the 20th, the court issued findings of fact and conclusions of law.
On the original? On
the trial.
Did I refresh my recollection? Did I issue those or was that a previous judge?
No, that was Judge Crump.
Judge Crump who
She
issued.
heard the trial. Yeah, we had like an afternoon and a morning of testimony that we put on,
Mhm.
and she made findings of fact and conclusions of law based on that.
Mhm.
And then he filed the motion for new trial, and there was a hearing, but there was no evidence. So I don't see any facts that could
Yeah,
be
I hear
found.
what you're saying. Let me I'm going to have to look into that a little bit more. I tend to agree with you. We're trying to give him something here for his time. But it may be that we can't do it because, as you point out, there was no evidence. There were no facts. There was no evidence submitted. There were no witnesses. And there's already been some finding of facts, conclusions of law. So, yeah, so what we were thinking was just the basic, the court finds on February 5th that the court denied petitioner's motion for continuance, refused to participate in final trial, and voluntarily left. So that's kind of the basic. That's all there is. So let us look into that some. We're trying to just not create more work for anybody, but just be very careful because it's unusual. I don't know that we've ever had it before that I can recall. Someone requesting findings of fact, conclusions of law on a motion for a new trial. Typically, it's the final judgment, and I must admit that's an area that I have not dug into because we don't usually get those requests. So we'll look into it. There's no reason to be overly concerned. The court has lost plenary power on issuing other orders today. All right, Mr. Lamnisos, we're going to give you the last word, and then we need to move on to other cases. Okay?
Okay, Your Honor, thank you so much for your graciousness. The question I wanted to ask, actually, although I can't ask the court or the professor for a legal advice, but if you could only correct, I mean, my understanding for finding of facts and conclusion of law is on what evidence did the court base its judgment? And the conclusion of law is what law did the honorable judge base their finding of facts or judgment? What law was applied or correlated with this judgment? So that is my understanding. And my question to Your Honor, that was it. Like, isn't that what a finding of fact and conclusion of law? I mean, if the court issues such a judgment,
the situation is this: you did not come to the divorce hearing. What I understood is you walked out, and so I can't.
because there shouldn't be divorce hearing.
Stop. But
Yes.
when I'm reviewing a motion for new trial, you're making that. I'm looking at the order. That's what I have. I'm not. There weren't new witnesses. Wasn't new evidence. It was just exactly what Judge Crump looked at, and you already got findings of fact and conclusions of law on those.
I did not, Your Honor.
Please be aware of that. All right.
You can look at them, Your Honor, and you will find that there was absolutely nothing in there. Just reiteration of what Ms. Longwitz put in her proposed dissolution. There was absolutely no mention to any evidence, any testimony, anything, nothing. And that is what I needed to challenge the so-called final order on divorce. Now, the other issue is when Ms. Lundwitz, what Your Honor mentioned that what I was trying to say when you asked me to give you a moment is just that if Your Honor is willing to reconsider or have a look at these two motions, whether to set aside default judgment or
No, see, I don't have plenary power. This is what Ms. Longwitz is saying. I have lost plenary power.
I understand.
Only thing I could still do potentially for you, and I'm trying to do something for you, are the findings of fact and conclusions of law. Now, that's what I'm trying to do, and I'm not. No, I'm not sure that's appropriate. Okay. All right, so you've got 5 minutes. Please wrap up, and then we need to go into other cases, Mr. Lamnisos.
Mr. Lamnisos, you need to unmute. And as a reminder, the court reporter cannot take a record when two people are talking at the same time, Mr. Lamnisos.
Thank you. I'm trying very hard, trust me. what I was trying to say, Your Honor, as far as the plenary power, I am not, the plenary power is concerned with the final judgment on the case. And I'm not asking the court today to issue a new order, hear a new motion, or argue the final order. I'm merely asking the court to correct the order because that additional paragraph practically, for all intents and purposes, render the order void and unnecessary or moot or whatever you want to call it. I did not need an order to get the transcript for ordinary appeal. I needed it because the law is not clear as far as writ of mandamus that it should be dealt with as an ordinary appeal. And as far as the issuance of finding of fact and conclusion of law for the Your Honor already issued that. So, I mean, if that's what's going to contain, I don't see the need to waste Your Honor time with that.
So
The finding of,
okay, are
yes.
you withdrawing that request then?
I did not. I mean,
Oh, are you, you just said, I don't know, there's no reason to waste my time with it. My question is, are you withdrawing that request?
Your Honor, I'm talking right now about, you just mentioned that the finding of fact and conclusion of law for the new trial, Your Honor already signed an order saying that there are no finding of fact and conclusion of law.
Right.
And that's exactly thank you so very much. This word or this sentence is worth $2 million for me. Thank you. It does not look right. And that is my issue with this whole situation. Nothing looks right.
All right, so we've got 3 minutes left, Mr. Lemnisos. We've given you the floor quite a bit today.
Thank you so much.
Anything else by way of reply?
I don't have anything else, Judge.
All right, very good. Thank you both for being here this morning. We're going to have our morning break of 15 minutes. Ms. Lungvitz, Mr. Lemnisos, you may be excused. Have a good rest of the day. The court will be on a brief recess. We'll come back in 15 minutes. Please be mindful that if you've got the microphone on, we can hear what you say in here. So you might want to turn your microphone off. All right. Thank you both. Have a wonderful day.
So
Goodbye.
we're still in the
May be
court,
excused.
right? We should be back, right?
You're done. You are done for the day. Goodbye.
Oh, we're done for the day.
Yes, we are done for the day. Goodbye.
Okay. Thank you. Thank you, Aaron.